So, welcome again to this video on legal techniques and logic. Today, we're going to talk about a very important aspect of lawyering, a skill set that you will have and try to develop as you become lawyers, or for lawyers here listening and watching this video. This is something that you do and I do on a regular basis. It's argumentation. Argumentation is very important in lawyering. It is something that the profession um, is built upon one of the factors, not the sole factor, in which the profession is built upon, and one thing that lawyers really do on a regular course of basis. My name is Francis Tom Temprosa, and this video on legal techniques and logic is about legal argumentation. This is the first part of the series. So, I will not focus on everything about legal argumentation. There are some areas of legal argumentation that, however, are very important to discuss. The first one is on procedure. Lawyers argue about procedure, and procedure is very important. The second one is on interpretation. Lawyers argue about interpretation. And those are the two things that will be focused on in this video, in this part one of the series. Do check out part two on two other areas of legal argumentation. So now let's go to procedure. Why does procedure matter? Different bodies of law could have different and sharply differing approaches to determining responsibility, rights, and duties. And so, process and even substance are also intertwined and often inseparable. So, for example, your opponent has the better substantive argument. You can counter that with procedural arguments that can change the substantive rules or make your opponent's argument difficult to make. And that also applies vice versa. So, procedure is important, not just substance. Before we dive deep into concept of different procedural arguments that can be made in legal argumentation, I want to point out that um, it's important that you argue for procedural benefit. To win or lose, it really depends on the substance, but at the same time on your procedural advantage. As a lawyer, someday it's likely that it will benefit you that the case that's in your favor, decided in your favor, has had good procedural basis, and the safeguards are there. So the point is, make sure that what you argue will redound to your benefit when you use procedural arguments. Let's not go now go to the first one. This is not an exclusive list, but the first that comes to mind is really about jurisdiction. Litigants and lawyers can argue that the court doesn't have jurisdiction or the power to hear and decide on the case. A lawyer can defend a client from charges of a crime or any other claim, civil claim, by challenging the jurisdiction of the court. And we must remember that jurisdiction is essentially based on law. It can also be argued that the court is biased, the judge is biased, has a conflict of interest, and should be recused from the case, or the jury should be recused from the case. Voir dire, that's the procedure. Another legal technique that can be employed is one that pertains to framing. When you are the counsel for the petitioner or the plaintiff, or you're the prosecutor, you have the power to frame the case before the court in your initiatory pleadings and also in the start at the start of the proceedings of the case. When you are for the defense or the respondent or the defendant, you can also reframe the questions that could be asked before the court. You do this through procedural matters, through through pleadings, and through other means. So another very interesting thing that you can also, as a technique that you can employ, is to reframe the issues that are before the court. That is a very vital technique. The other technique that a lawyer employs is to argue which rules apply. It can be Rule A, Rule B, or Rule C, or any other number of rules. So when a rule applies, the procedural implications are there, and also within the procedure, you can apply that this rule of procedure applies over others. You can also employ the technique of interposing a counterclaim. A counterclaim is essentially a claim against the other party, and this is more of an offensive rather than a defensive um, posture. But this one radically also impacts the procedural aspect of the case because you're claiming against the other party that claims against. Let's go to standing. Standing is the right to sue. In many cases, in different legal systems, not everyone can sue. People who are allowed to sue are people who suffer injury or people who have direct and protected interests, legal interests. And you can argue that the other party that sued you doesn't have standing because he doesn't have injury or he doesn't have legal interest that's protected by law. So this one is very important and gains a very popular dimension in public interest cases. If you're counsel for the defense or the respondent, you can also say that the complainant is tainted. Examples are the defendant arguing that the complainant is impar delictus, to quote, quote, doesn't have clean hands, or has contributory negligence. Um, the rationale, for example, for impar delicto is that one should not benefit from shared wrongdoing, and the court is not available to reallocate losses between wrongdoers. One can also argue that it's too early. Um, Here there are two lines of arguments. The first one argues that the dispute is not yet a real dispute. It is not ripe. This could be because the complainant has not yet been harmed. The forum chosen is reserved for actual disputes where harm is experienced or has been experienced rather than potential disputes. And the second line of argument could be if you can argue that it's too early, you can certainly say that it's too late. Of course, it depends a lot on the factual circumstances of the case. It's too late when there are the statute of limitations has set in, or prescription, or the concept of repose is applicable. The legal concept of repose is that after a substantial enough period of time, expectations are settled, and it will be too much of a disturbance to revisit old issues. So, the concept of statute of limitations or repose is readily applicable to interpersonal relations. Let's go to burdens of proof. There are two types of burdens of proof. One is the burden of bringing forth evidence of a particular position, or that's the burden of production, and the other one is the burden of persuading the decision maker of the correctness of his position. That's a burden of proof per se. This is extremely important in many public policy and personal decision making contexts. What the reading says. Because whoever has the burden should produce evidence, and whenever there is no evidence produced, then you can rightly argue that the burden has not been discharged, and that goes into your favor. You can also bring up questions of enforcement, remedies before the court. There are two questions here. First, will the tribunal or decision maker um, order the remedy that you wish? This can happen that the court doesn't have the power to order the remedy. Second is assuming that the court orders the remedy um, or grants relief. There is a question of whether the defendant can be forced to comply. The defendant could have insufficient resources, for example, to comply, or could be immune from the power of the court. You can also argue that the case has already been decided. Examples of arguments that fall under this or reasons are res judicata, collateral estoppel, repose, and double jeopardy. It just means, for example, in res judicata, that once a case is finally decided, after the appeals have been exhausted, it cannot be heard again. So, at some point, litigation has to stop. Of course, last but not the least, you can also argue that the process that was followed is flawed. In this case, I think it's worth mentioning that behind every procedure or procedural rule is a process value. Process values are, lawyers easily dismiss them as technicalities or even loopholes, but in the legal profession and in a rule of law society based society, um, process values are real values that sometimes should overcome substantive values. This is what the reading tells us. um, they are there for a reason. Good process is a central component of good management and good policy making, and they are also integral to a careful analysis of legal thought. So that's it. I hoped that, and I really wanted to have interpretation discussed in this video, but that's not possible given the length of this video now. In the next video, in part two, join me as I discuss interpretation before moving to the last two processes or areas rather of legal argumentation.